Welcome to the Senate Judiciary. Please proceed.
Good evening, Mr. Chairman and members of the committee. My name is Kelsey Bala. I'm a Senior Policy Associate at Rhode Island Kids Count. Thank you so much for the opportunity to provide testimony today, and thank you for bearing with us on this very long evening. We would like to thank Senator Vargas for introducing this important bill, as well as all co-sponsors. Rhode Island Kids Count strongly supports Senate Bill 2940, which would reestablish a full-time Juvenile Hearing Board state coordinator at the Rhode Island Family Court, automate referrals to hearing boards for youth charged with first-time misdemeanor, and require an annual data report. Juvenile Hearing Boards, or JHBs, as you've already heard, provide a community-based option that diverts youth accused of low-level offenses, including status offenses and misdemeanors, from formal court involvement. Youth complete sanctions such as community service, restitution, and, as you've heard, counseling, and are often able to avoid having a formal court record following this process. In my written testimony, you'll see a chart outlining youth who were referred to JHBs in 2024 by offense type, and the majority of cases were for disorderly conduct. Senate Bill 2940 updates statute established back in 1998 and 2000 that enabled the Chief Judge of the Family Court to appoint a statewide Juvenile Hearing Board coordinator and reestablish that one FTE at the Family Court for that role. This bill would also automate referrals to the JHBs for first-time misdemeanor offenses. Some municipalities already practice this, and they send their first-time misdemeanor cases straight to the JHB, which is an excellent practice to standardize across the state, which would both improve equity and outcomes for all youth. Research shows that diversion improves youth outcomes, including lowering recidivism rates. Still, youth of color are diverted at much lower rates than their white peers. There's also a refusal clause in this bill, so if a family prefers to have their case go through the family court, that is their right to do so. We would also recommend one small amendment to page 2, lines 19 to 20, which states juveniles shall be referred to the hearing board in the municipality in which they reside. We recommend amending that to juveniles shall be referred to the municipality in which the alleged offense occurred. So this would align the language in subsection C with B and align with current practice in the field of referring a youth to the Juvenile Hearing Board in the municipality in which the alleged offense occurred to restore the harm that was done and caused in that community, which is a restorative justice practice well aligned with the ways in which youth learn from their mistakes. So to close, we know that alternatives to formal justice involvement have been shown to be more effective in preventing recidivism, they're more cost effective, and they are often the more appropriate response to developmentally typical child and adolescent behavior that is sometimes criminalized. Senate Bill 2940 will ensure youth and their families are connected with community-based services and supports and help Rhode Island continue its path of youth justice reform, and we urge passage. Thank you for the opportunity to testify, and you'll also find a Rhode Island Kids Count fact sheet attached to my written testimony.
Thank you.
Thank you.
For your testimony.